Hello, and thank you for watching. My name is Bradford Roberts, principal broker, founder, and owner of TR Realty in the Las Vegas area. After watching this video, please be sure to like it as well as subscribe to our YouTube channel. Download the pertinent handouts for this video by clicking the link in the comments below. Now let's get started. All right, let's take a look at paragraph 8, which says fees and prorations. Quite a few things in this paragraph that I want to cover as well. It says there on line 25, identify which party shall pay the cost noted below. And then you've got those 5 choices, which should be familiar to you by now. You've got seller, you've got buyer, 50-50, waived, or NA. Those are the 5 choices. So everything in 8A, which is the title, escrow, and appraisal section, should be indicated with one of those 5 choices. And just like we did in paragraph 7D, I'm going to give you my recommendations, keeping in mind you might not agree with me because they're all negotiable. So that's what a recommendation is, right? It's not a law, it's not etched in stone, it's just what I am recommending. So the first choice in 8A is escrow fees. My recommendation here is 50-50. That the buyer and the seller share 50-50 the cost of those escrow fees. Next, we have the real property transfer tax. My recommendation is this goes to the seller. The next one is the lender's title policy. Think of the name, lender's title policy. This should go to the buyer, in my opinion, but only when there's a lender. So it would be foolish, and you would show how inexperienced you were if you said someone's going to pay for a lender's title policy in a cash transaction. In a cash transaction, there is no lender, therefore there's no lender's title policy. But if there is a lender, I think this should go to the buyer. Next one up is the appraisal, which typically goes to the buyer as well. And the next one after that is the owner's title policy, which typically and traditionally goes to the seller. All right, so there are my recommendations in 8A. Let's take a look at 8B, which says prorations. Now, the word proration means we're going to do a mathematical calculation based on the day of conveyance. So a proration is a sharing of an expense. And when we prorate something between a buyer and the seller, we have to look at the actual date of conveyance. And before that date of conveyance, that portion of time for that expense would be paid by the seller. After the close of escrow, that's going to be paid for by the buyer. And we typically use a very informal way. Who is going to go to sleep in that property tonight? So example, if we close escrow at 4 o'clock in the afternoon, typically that day is going to be charged to the buyer. Again, using that test, who's going to go to sleep in the property tonight, okay? So 8B says any and all rents, taxes, interest, homeowner association fees, trash service fees, payments on bonds, SIDs, lids, and assessments assumed by the buyer, and other expenses of the property shall be prorated as of the date of recordation of the deed. Let's go back. I want to hit the word rents. So it's only recently that the proration of rent has been addressed in our RPA. So we used to have special language that said as of the date of closing or the date of recordation, that rent is going to be prorated because typically the tenant will pay rent at the beginning of the month. So if we close escrow during that month, the buyer, the incoming owner, is going to be entitled to the portion of rent that would apply to his period of ownership, right? But we don't need that special language anymore because the proration of rent is already dealt with in this paragraph. Let's move on to line 32, where it says security deposits, advance rentals, or considerations involving future lease credits shall be credited to the buyer. All right, let's take a look at that. So if the property has a tenant in place, chances are the current owner of the property is holding the security deposit. Well, if the tenant is going to stay after the moment of recordation, now the tenant becomes a responsibility of the incoming owner, the buyer, right? So that security deposit needs to convey from the seller to the buyer, and we want to do that through escrow. We want to make it part of the transaction. The reality is that when you're dealing with a lot of individual owners, they haven't kept that security deposit separate anyway. They've mixed those funds. They have probably spent those funds as well. We want to make sure that money is available for the buyer, because now in the future when the tenant moves out, it's the buyer who's going to have to refund that security deposit if it becomes refundable. So again, we used to have language, but paragraph 8b clearly calls for the conveyance of the security deposit from the seller to the buyer. And that brings up an interesting topic, and that is when we are dealing with the conveyance of a property with a tenant. There's three things that we need to consider when we're selling a property that has a tenant. One is the proration of the rent as of the day of close of escrow. Well, that's in here. The second is the transference of that security deposit from the seller to the buyer. Well, that's in here as well. But there's one more thing that is not in here, and that is getting a copy of the lease. It's really important that the buyer gets a copy of the lease, because the lease supersedes the conveyance. The buyer cannot automatically kick the tenant out of the property. We probably know this from other of my videos that you might have watched by now. So what if the lease has some ridiculously low rent or some ridiculously long period of time, like a 20-year lease on a house or something like that? The buyer would have to honor that. Well, that's crazy. So the buyer is entitled to getting a copy of the lease. We're going to be talking about that, but that is the one out of three issues that for some reason this template RPA has not dealt with, okay? So when there is a tenant in place, we're going to have to address getting a copy of the lease, and we're going to have to get a copy of the lease during that due diligence period. The paragraph continues by saying all prorations will be based on a 30-day month. So February and August have the same number of days for our contract. It says, and will be calculated as of close of escrow. Prorations will be based upon figures available at closing. Any supplementals or adjustments that occur after COE will be handled by the parties outside of escrow. Let's move forward to 8C, which talks about the preliminary title report. If you have not already done so, I highly recommend you watch my video series, Class 2, my segment on title and escrow. We do talk about the PTR. And if you're not clear at this moment what a PTR is, where it comes from, what we do with it, you've got to go back and you've got to watch my video series, Class 2. It says on line 37, within 10 business days of opening of escrow, title company shall provide buyer with a PTR to review, which must be approved or rejected within 5 business days of receipt thereof. If buyer does not object to the PTR within the period specified above, the PTR shall be deemed accepted. If buyer makes an objection to any item contained within the PTR, seller shall have 5 business days after receipt of objections to correct or address the objections. If within the time specified seller fails to have each such exception removed or to correct each such objection, buyer shall have the option to terminate this agreement by provide notice, etc. So that is what I want to cover in paragraph 8C. Let's take a look at 8D. This is, in my opinion, one of the most poorly worded paragraphs in this entire RPA. In fact, I hate this paragraph. I hate the way it's written so much that I recommend you don't even use it. I have another way to accomplish the goal of this paragraph, in my opinion, in a much better way. So let's take a look at this, and it might make sense to you. D is about lender and closing costs. Lender and closing costs. It says, in addition, notice that's bold, in addition to seller's expenses identified herein. So we've gone through a lot of things. We've talked about the seller might be paying for a termite inspection or other kinds of inspections, expenses that relate to the common interest community, etc. But in addition to that, seller will contribute X amount of dollars to buyer's lender's fees and or buyer's title and escrow fees. Some agents think you can't use this in a cash transaction. Well, they haven't read it clearly, because this money could be contributed to lender's fees or the title and escrow fees. So it absolutely could be used in a cash transaction. Now here comes the terrible, tricky part. It says including or excluding costs which seller must pay pursuant to loan program requirements. Different loan types, example, FHA, VA conventional, have different appraisal and financing requirements which will affect the parties' rights and costs under this agreement. So we have to make a choice if we use this paragraph. And again, I'm recommending we don't use this paragraph. But you still need to understand it, because other agents will write offers and they'll use it, and you need to understand it. Including or excluding costs which seller must pay. If you choose including, that choice will favor the seller. If you choose excluding, that will favor the buyer. Here's why. If you've got costs that the seller must pay, let's say example, a VA loan. I told you that the seller has to pay certain things, and right now they're averaging about $1,500. This paragraph says, in addition to that, the seller is willing to contribute more money to the buyer's expenses. If you choose including, and you put some amount of money, it's going to be that amount of money minus what the seller already has to pay. If you put excluding and some amount of money, whatever the seller is required to pay doesn't count. So they're going to get what the seller is required to pay plus this other amount. So let me say it again. Including favors the seller, excluding favors the buyer. I still recommend you don't use this. I recommend you leave this paragraph blank, that you take my clause from my clause library that talks about recurring and non-recurring closing costs. Watch my video series class 3. Watch my video series class 4. You're going to get all of those clauses in the clause library, which, by the way, is a handout in those classes. Take that language about recurring and non-recurring closing costs, put it down in paragraph 28 in your additional terms. It is much better, it is much more clear, and you're a lot less likely to make a mistake. Let's take a look at 8E, which is the home protection plan, otherwise known as a home warranty. Buyer and seller acknowledge they've been made aware of home protection plans that provide coverage to the buyer after close of escrow. Now here comes the tricky part of this paragraph. Buyer waives or requires a home protection plan. You need to choose one. If you choose buyer waives the home protection plan, then the rest of this paragraph must be blank. If the buyer is waiving it, it stays blank for the rest of the paragraph. But if you choose buyer requires a home protection plan, now on line 10, you have to tell me the name of the company. And of course, we love BFS Home Warranty, and we also love Landmark. Landmark takes care of our Boulder City office and our other offices that will open on the perimeter of the Las Vegas Valley. BFS is our preferred warranty company in the Las Vegas Valley area. So you have to put, you can't put TBD, that will not work. Okay? You can't put seller's choice. Please put the actual name of a warranty company here. And if you choose buyer requires and you put the name of the company, now you have to tell me who pays for it. Seller or buyer will pay for the home protection plan. If you say buyer, then I don't need to know what it costs. But if you're asking the seller to pay for the buyer's warranty, then on line 11, you have to put a maximum price. not to exceed. Typically, this is a few $100s, but if you're asking the other side, the seller side, to pay for the warranty, you need to find out. You need to contact the home warranty company that you're choosing. And again, I'm recommending BFS or Landmark. Find out what a warranty costs for that type of home and that type of coverage that the buyer wants, and you need to fill that out. All right? So, again, if you put on line 9, buyer waives, the rest of the paragraph is blank. If you put requires, you've got to fill in the name of the company and tell me who pays for it. And if it's the seller paying for it, you need to tell me the amount also. That is paragraph 8. Let us take a look next at paragraph 9. That says, upon close of escrow, buyer shall tender to seller. To tender just means to give in a nice way, in an agreeable manner. Buyer shall tender to seller the agreed upon purchase price, and seller shall tender to buyer marketable title to the property, free of all encumbrances other than 1, current real property taxes, 2, CC&Rs, those apply to a common interest community, 3, zoning or master plan restrictions and public utility easements, and 4, obligations assumed and encumbrances accepted by buyer prior to close of escrow. Buyer is advised the property may be reassessed after close of escrow, which may result in a real property tax increase or decrease. We don't know what the taxes are going to be once this property conveys. Paragraph 10 is about common interest communities. So obviously, this is an important paragraph. If the property we are intending to sell is located within a homeowners association, a condo association, or a cooperative association. If the property is subject to a CIC, seller shall provide at seller's expense the CIC documents as required by Nevada law, collectively called the resale package. Seller shall request the resale package within 2 business days of acceptance and provide the same to buyer within 1 business day of seller's receipt thereof. And the important part of that paragraph is there on line 21 in bold print, at seller's expense. So even though Nevada law has changed over the years, the current law requires the seller to pay for and provide the resale package. This is not something that is negotiable or reimbursable. This is flat out a seller's expense. Bringing your attention to line 25, pursuant to Nevada law, buyer may cancel this agreement without penalty until midnight of the 5th calendar day following the date of receipt of the resale package. So that is a clear reference to Nevada law, which gives a 5 calendar day right of rescission to a buyer of a property within a CIC. And that 5 calendar day right of rescission or cancellation does not start ticking until the buyer actually receives the resale package. So the timing of the resale package is really important. If the seller purchases and delivers the resale package too soon, then, and if he does so within the due diligence period, the loan contingency or the appraisal contingency, what can happen is the buyer still has that unilateral right of cancellation because of those contingencies I just mentioned, and the buyer can walk away, and that resale package is not reimbursable. So that is a seller's expense. He paid for that resale package, and now the buyer has walked away. If he orders the resale package too late, he's in breach of the contract, and also he's in a situation where he's keeping the buyer's right of cancellation alive. And that is because of that 5 calendar day cancellation right that the buyer has. This cannot be shortened or waived in a contract or with some language. It is statutory. So it is in our law. 5 days is 5 days is 5 days. That's it. Cannot be changed. So that's what that paragraph is about. Line 29, if buyer does not receive the resale package within 15 days of acceptance, this agreement may be canceled in full by buyer without penalty. So that is another reference to what I mentioned a minute ago about the timing of the ordering and the delivery of that package. In line 32, it says, upon such written cancellation, buyer shall promptly receive a refund of the EMD. The parties agree to execute any documents requested by escrow holder, that's the title company in most cases, to facilitate the refund. If written cancellation is not received within the specified time period, the resale package will be deemed approved. Seller shall pay all outstanding CIC fines or penalties at close of escrow. So if you go back to my video series, Class 2, Title and Escrow, we talk about the what a lot of people call demand letters, which are really estoppel letters. That is how the title company will ascertain whether the seller owes any fines or assessments, and that's how we can get them on the settlement statement, get them paid at close of escrow, and that will ensure that the buyer does not inherit any of those seller's expenses. Let's take a look at paragraph 10A that says CIC related expenses. And you can already see, I know you're looking ahead of me here, you can already see that we're coming up to another one of those now famous boxes where we have the 5 choices: seller, buyer, 50-50, waived, or NA. So taking a look at this box, once again, I'm going to give you my recommendations. Recommendations, folks. For the third time, I'm mentioning that these are negotiable. They're not etched in stone. They're only my recommendations. You might choose to put something different, but this is what I would put. Where it says CIC demand, I'm going to put seller over here. And that is the letter that is being sent to the common interest community to determine what fees and expenses have to be paid prior to close of escrow. Those are seller expenses that need to be paid. Therefore, I believe it is the seller who should pay that demand. The next one there is the CIC Capital Contribution. If you don't know what a capital contribution, capital refers to money. Contribution, the word makes it sound like it's voluntary somehow, but it's not. Nevada law requires a common interest community to have a certain amount of money on reserve, like a savings account. If their reserves fall below a certain amount of money, they are allowed to go to the unit owners or homeowners in that community and ask for money. Ask for a bailout, basically, is what it is. That is a capital contribution. In my opinion, this should be paid by the seller as well. The next one in the box is the transfer fees. Common interest communities will profit from this. They will charge a fee to transfer a property from a seller to a buyer. I guess there's a lot of time involved to go to the directory and change somebody's name or to transfer their records or whatever. Of course, I'm being facetious, but nonetheless, they charge transfer fees. It's my recommendation that this goes to the buyer. Now, we also have a space to put other. There's actually something that I recommend you put here. I recommend where it says other, you write in the words SIDS and LIDS. If you don't know what SIDS and LIDS stand for, you have not watched my Class 2 video series where I explain SIDS are Special Improvement District, LIDS are Limited Improvement District. These refer to another type of assessments that might be imposed by a common interest community or by a municipality. It is my opinion that SIDS and LIDS get written in where it says other, and then it's completely negotiable. It could go either way, who pays for them, seller or buyer, or we could do a 50-50, or we could do waived or not applicable depending on the circumstances. But this would be a way of getting SIDS and LIDS into the contract. There's no other space for it, and since SIDS and LIDS are typically tied to the common interest community expenses, this is exactly where I would put it. And that is my opinion about paragraph 10. Let's move right on to paragraph 11, which has changed significantly, and I will tell you why. Paragraph 11 is about the disclosures. It says, within 5 calendar days of acceptance of this agreement, seller will provide the following disclosures and or documents. Check applicable boxes. So we need to check the boxes that would pertain to the disclosures we want the seller to provide to the buyer. Let's go through these so we understand them. The first one on line 43 is the seller real property disclosure form, what we call the SRPD. In my opinion, this box should always be checked. The rare exception would be if the buyer's agent, who's probably filling out this offer, somehow has the knowledge in advance that the seller is exempt from providing the disclosure. And we have talked about in other videos who is exempt from providing the SRPD. And that is new construction, it is close family members, it is trustees, and it is co-owners of a property who would be exempt from the SRPD. In all other cases, there's no exemption, and we would need to check this box. This is not something you would typically know in advance, so I would probably go ahead and check this box in every case. To the right of the SRPD, you notice there's one that says open range disclosure. Nevada is an open range state. If you don't know what that means, it means that animals have the right to roam freely around our state. And if you don't like animals on your property, then you are allowed to do something to keep them off. You're allowed to build a fence or a wall or an electronic system, as an example. But animals do have the right to go wherever they want to go. We do have a lot of wild animals in Nevada. By the way, most states west of the Mississippi are open range states. Most states east of the Mississippi would actually require someone who has animals to contain them. So on most states on the East Coast, you would actually have to build some kind of a barrier to keep your livestock or to keep your animals on your property. They do not have the right to roam freely like they do in an open range state such as Nevada. If you are writing an offer on a property that is adjacent to BLM, to Bureau of Land Management land, which is open land, or if you are on the periphery of town and you're writing an offer on a property that might be adjacent to a property that has animals on it, it's probably good to err on the side of caution and go ahead and request the open range disclosure. The next one down is the construction defect claims disclosure. It says to go ahead and ask for this if the seller has marked yes to paragraph 1D of the SRPD. Well, that's all well and good, but most of the time you haven't seen the SRPD before you write the offer. So my recommendation is to go ahead and check this box and ask for it. This is going to let the buyer know if there is any kind of litigation that might be with the builder, if there's any kind of known construction defect problems on the property. So I like to err on the side of caution, and I like to ask for this. The next one on the list is the lead-based paint disclosure and acknowledgement. You can see it says there it's required if constructed before 1978. So when you look at the tax records, if they say 1978 or later, you've got nothing to worry about. If the tax records say 1977 or before, then you should go ahead and request this lead-based paint disclosure. Make sure you pay careful attention in my Class 3 and Class 4 video series where we talk about lead-based paint. It's federal law that agents get this right. It's a really, really big deal. So on an older property, built in 77 or before, go ahead and check the box requesting lead-based paint disclosure. And then when we go to line 47, we have another opportunity for other. And there's actually something that I like to put in here as well. And that is known as the Supplemental Property Information Form. Supplemental Property Information Form. Now, I have covered this in my Class 4 video series. It was one of our handouts there. But this is a form where the seller's going to tell us if he's filed bankruptcy. The seller is going to tell us if he's behind on his association payments, if he's received a notice of default or a summons and complaint. If you don't understand what I'm talking about right now, please go watch my video series Class 4 where we cover this in great detail. But For the purposes of today's video, it is my recommendation that on line 47, we check the box that says Other, and we write in the words Supplemental Property Information. All right? Now, I told you I'd address why this has changed. Paragraph 11 has changed so much. That's because our association has decided to remove anything that was never legally required. In other words, there used to be disclosures, and there are still some disclosures that might be convenient, might be helpful, might be smart or prudent, but could never be legally required. So the association has taken them out and given us a chance to write them in where it says Other. And they've left paragraph 11 only with the disclosures that in some cases could be legally required. So that's why they completely restructured paragraph 11. Okay, we are now ready to turn to page 6 and take a look at paragraph 12. This is the Federal Fair Housing Compliance and Disclosures. It says all properties are offered without regard to race, color, religion, sex, national origin, age, gender, identity, or expression, familial status, sexual orientation, ancestry, or handicap, or any other current requirements of federal or state fair housing laws. So at TR Realty, I am adamant about adherence to all of the fair housing laws and amendments, and we will not tolerate any kind of discrimination of any sort in this company. And what this paragraph is saying is that we will not allow our clients to do that either. All right, paragraph 13 talks about the walkthrough inspection of property. We are now supposed to refer to this as a walkthrough verification. I anticipate that the next time this RPA is updated, the association will be changing that language. It says buyer is entitled under this agreement to a walkthrough of the property within some calendar days prior to COE. So this works in reverse. It's a number of days before we actually close escrow, to ensure the property and all major systems, appliances, heating, cooling, plumbing, and electrical systems and mechanical fixtures are as stated in the SRPD, and that the property and improvements are in the same general condition as when this agreement was accepted by seller and buyer. My recommendation here is 1 to 2. Again, not to put a range, but to put 1 or 2. Now, I know that some brokers like to put a longer time frame here, maybe 3, 4, 5 days. And the thinking is that it would give the agents time to work things out, give the parties time to work things out. If there were something that were not copacetic at the property, there would be some negotiation time. I understand that strategy. It's not mine. I want to share with you my strategy. So I have seen countless cases over the years where a buyer and buyer's agent will go to the property to do a walkthrough 3, 4, 5 days before the actual close of escrow. Everybody knows that is the last chance the buyer has to see the property before they actually put their money on the table and take legal ownership of it. And in that window of time that is created between the walkthrough and the COE, anything can happen. The air conditioner can freeze up, the hot water heater can explode, there can be a break-in of the property, there could even be an unethical seller or unethical listing agent to go back to the property and to start doing things, removing things, stealing appliances, that sort of thing. And in my opinion, the shorter that window of time that someone would have to mess with the property or for something to break down, the better. So that's why I like that very, very short and tight window of time. Now, you might be thinking, well, what about negotiation? What about if something's wrong? So if something's wrong at the time of the walkthrough, actually what's probably happening here is the seller is defaulting on the contract. So as the buyer's agent who is going to initiate and facilitate that walkthrough process, I don't have any stress. I'm not concerned with the fact that we're supposed to close escrow tomorrow because I feel the burden is on the listing agent and the seller. Let me give you an example to illustrate what I'm talking about. Let's say we have a purchase and sale agreement that says the seller is going to replace a broken dishwasher prior to close of escrow. And we get to the property to do our walkthrough the day before close of escrow, and we notice that the dishwasher has not yet been replaced. Which party is about to breach the purchase and sale agreement? Obviously, it's the seller, because the seller agreed to replace the broken dishwasher and he has not performed. So he is about to breach. And that would give us that opportunity to do that funds held supplemental escrow instructions that we talked about in my Class 3 video series, wherein the parties are going to agree for some amount of money to be held back by the title company. It will allow them to go ahead, close escrow, record the deed, disperse the funds, all except for that amount of money that is being held to ensure performance. Now, for those of you who have already watched my video series Class 3, you probably know how the funds held supplemental escrow instructions works. You probably know that we give the parties X number of days to perform. If they don't, then the money that is being held by the title company is typically released to the buyer at that point. So then the buyer has the funds to do the correction, such as replacing the dishwasher that I just talked about. So I like that nice, tight, short walkthrough verification period. It's just my strategy of how to handle this. And line 9 says, to facilitate buyer's walkthrough, seller is responsible for keeping all necessary utilities on. All utilities on. Yeah, we can't do a proper walkthrough if the utilities are not on. And in my video series Class 3, when I talk about the walkthrough verification report, I did talk about what to do if areas are inaccessible or utilities are not on. So please make sure you reference that video. And I'd like to bring your attention down to line 13, toward the end of the line, the bold print, where it says, if buyer elects not to conduct a walkthrough inspection prior to COE, that would be a really stupid buyer, by the way, then all systems, items, and aspects of the property are deemed satisfactory, and buyer releases the seller's liability. Think about that. If the buyer fails to conduct the walkthrough, he is releasing the seller's liability. So, once he takes ownership, pays for the house, gets the keys, and moves into the property, if he discovers something is wrong and he believes it was wrong before the actual close of escrow, he's out of luck. He has waived the seller's liability by failing to do the walkthrough. And one more thing I want to mention as we're covering this paragraph 13. I covered this when we did the video on the walkthrough. And that is that the real estate licensee can never, ever be the representative for the buyer at the walkthrough. So the walkthrough verification form, please go take a look at that from Class 3. It does have a place where we indicate whether the buyer has done his own walkthrough. That's really what we want. Or the buyer has appointed someone else, a relative or a friend, to do the walkthrough. That's fine. He can also send his inspector back to the property. That's fine. And you should be there with the buyer if the buyer does a walkthrough, but you can never, ever be the authorized representative. That is an absolute blatant conflict of interest, that you would be the person looking around the property saying, yeah, this is okay, let's go ahead and close, because you have a financial interest, right? You want to close and you want to get paid on the transaction. So we have a strict prohibition that the buyer's agent cannot be the authorized representative for the walkthrough. Let us move on to paragraph 14, which talks about delivery of possession. Seller shall deliver the property along with any keys, alarm codes, garage door openers, controls, and if freely transferable, parking permits and gate transponders outside of escrow and upon close of escrow. Seller agrees to vacate the property and leave the property in a neat and orderly broom clean condition. I want to pause for a moment, because the term broom clean, in my opinion, is another one of those weasel terms. I'm not sure there's a legal definition or any legal enforceability to the term broom clean. Somebody might say that this is clean. The other person might say it's not clean. So in my opinion, this phrase here in paragraph 14 creates a pretty good loophole for the buyer to complain that the property is not in broom clean condition. And when I was selling real estate, I would use this phrase along with the funds held supplemental escrow instruction concept to get some money to be withheld for my buyers to have a professional cleaning service come and take care of the property at the seller's expense. So if that didn't make sense to you, you probably want to rewind, and you probably also want to go back to the segment where I talk about the funds held supplemental escrow instructions, and it should make sense to you at that point. And then it says, and tender possession no later than, and we have a choice to make here, either close of escrow or something else. My opinion is we need to check the box that says close of escrow. There's actually some legal dispute over the word possession, believe it or not. Does the word possession mean ownership, or does the word possession mean control? And some agents will struggle with this when the seller is going to stay over, or what we call a post-possession agreement. So in my opinion, we should always choose close of escrow just to be on the safe side. And it says, in the event seller does not vacate the property by this time, seller shall be considered a trespasser, in addition to buyer's other legal and equitable remedies. And then a very important sentence here. It says, any personal property left on the property, good English, huh? Any personal property left on the property after the date indicated in the section shall be considered abandoned by the seller. So once we have recordation of the deed, the property and everything in it now legally conveys to the buyer. The seller has no more legal right to go back to the property and reclaim anything that still might be there. Paragraph 15 is the risk of loss. It says, risk of loss shall be governed by Nevada law. The law generally provides if any or all material part of the property is destroyed before transfer of legal title or possession, seller cannot enforce the agreement, and buyer is entitled to recover any portion of the sales price paid. So what that means is, if something happens, like, an earthquake, a typhoon, a fire, a sinkhole, something happens and a material part of the property or all of the property is destroyed, we cannot enforce this contract anymore, and we cannot force the buyer to perform. The buyer would be entitled to get his money back. When I sold real estate in South Florida, every summer, pretty much it felt like it anyway, we had hurricanes come through and roofs blow off and trees fall down and smash into those properties. This is very closely tied to a legal concept known as force majeure, F-O-R-C-E, M-A-J-E-U-R-E. You might want to Google and look that up. I wish we had that in our contract here. The closest thing we have is this risk of loss, but basically we can't force the buyer to buy a house that has been severely damaged or destroyed. Let's take a look at paragraph 16 right now, which is the concept of assignment. Years ago, there used to be a box to check. This contract is assignable or is not assignable. But if you look at line 30 right now, it clearly says this contract is not assignable unless agreed upon in writing by all parties. And if you go back to the very beginning of my Class 5 video series, where we talked about John and Mary Smith versus doing something like John and or Mary Smith, we did talk about assignability, and that is how we could make the contract assignable. So hopefully you followed me when I was talking about that. But unless we do something to manipulate this contract, it is typically non-assignable. Paragraph 17 talks about the cancellation of the agreement. In the event this agreement is properly canceled in accordance with the terms contained herein, then buyer will be entitled to a refund of the EMD. Very important sentence follows. Neither buyer nor seller will be reimbursed for any expenses incurred in conjunction with due diligence inspections, appraisals, or any other matters pertaining to this transaction unless otherwise provided herein. I do get that question quite a bit. Well, the seller paid for the resale back package, and now the buyer exercised his right of due diligence and canceled the contract. The seller is demanding to be reimbursed for the cost of the resale package. No, doesn't work that way. And conversely, there are situations where buyers pay mortgage application fees, they pay for inspections, they pay for appraisals, and then somehow the seller can't deliver clear title, or maybe the seller can't deliver short sale approval, something goes wrong. But generally speaking, unless we manipulate or change this agreement in some way, those expenses that the parties incur are not reimbursable. And paragraph 18 is our default paragraph. You can imagine I get a lot of questions about default, so let's go through this one a little bit more slowly so we understand carefully. So there are three components to this, as you can see: mediation, seller default, and buyer default. Let's start on line 40 with the concept of mediation. Before any legal action is taken to enforce any term or condition under this agreement, the parties agree to engage in mediation, a dispute resolution process. And then actually it says here, through GLVAR. Well, there's two problems with that. One is GLVAR is not GLVAR anymore. It's now LVR. And second is they have gotten out of the mediation business. So they will be making those changes when they update this form as well. But it goes on to say, or a mediator mutually agreed upon by the parties. Mediation fees, if any, shall be divided equally among the parties involved. Very important sentence coming up. Make sure you understand. It says, notwithstanding the foregoing. Whenever you see notwithstanding the foregoing, it kind of means like, forget what I just said, regardless of what I just said. In the event the buyer finds it necessary to file a claim for specific performance, this section shall not apply. Let's talk about that. Specific performance is a concept of the law when a party breaches a contract. So in real estate specifically, the concept of specific performance might be a seller who is refusing to sign the closing documents, as an example, or a buyer who is refusing to bring closing funds to the table. So in that case, the parties do have the right here to circumvent the mediation process and go for something called specific performance. Easy for me to say, right? So I highly recommend they consult with counsel to do that. Specific performance can be a bit tricky, but what it means in simple English is we want to compel the other side in the contract to do what they said, to perform on the contract. And I want to back up here a little bit and make sure you understand what mediation is. So people often confuse mediation and arbitration. They're actually very, very similar, except for the fact that mediation is non-binding. That neutral third party who mediates a dispute is going to come up with a suggestion or a recommendation for the parties to follow, and the parties can follow it or not follow it. As opposed to arbitration, where the parties are agreeing beforehand that whatever that arbitrator decides, that will be the final decision, the binding decision. So this is just a process to try to get the parties to the table, to have a third party, a disinterested neutral third party, come up with a suggestion. Hey, I think this is how we should resolve this. And if you look down at line 46, you'll see that this requires initials by both parties. Now, let me address that. Whenever we see in a contract of any sort, whenever we see separate initials required, what that should tell you is if all parties to the contract do not initial that paragraph or provision, that paragraph or provision will not apply. So in this specific case, if we go to line 46, let's say the buyer initials here. The buyer is willing to mediate rather than file a lawsuit if there were some dispute with the seller. Now the seller gets this, and he chooses not to initial this mediation paragraph. In that case, folks, there is no mediation provision to the agreement. It would take that bilateral, two-party, that bilateral consent for that provision to be applicable. And you've heard me say before, I am a proponent of mediation. It is quicker, it is cheaper, it is easier, it is nicer than going to court, trust me. So we always want to try for mediation as a way to resolve our differences. Let's drop down to line 48 and talk about seller default. It says, if seller defaults in performance under this agreement, buyer reserves all legal and or equitable rights, such as specific performance, and we just talked about that, against seller, and buyer may seek to recover buyer's actual damages incurred by buyer due to seller's default. Now, I am not an attorney. And I am not trying to give anyone legal advice. But I have had a couple of beers with attorneys in my life, and I would like to introduce you, if you don't already know it, to the concept known as a lis pendens. That is two Latin words, lis pendens, lis pendens, which is a Latin phrase meaning lawsuit pending. Now that I mentioned I'm not a lawyer, so I can't give you legal advice, but what my lawyer friends tell me is that if a buyer were to file a lis pendens on a seller's property, the seller would be unable to sell that property to anyone else. In fact, I also heard from my lawyer friends that if a lis pendens was filed on a property, the seller couldn't even refinance the property. Of course, we don't care about that much. We are here to sell real estate. So, again, I'm not giving any legal advice to my viewers here, but it's my understanding that a lis pendens would preclude a sale to another party. So let's say, as an example, there were a dispute between the buyer and the seller, and the buyer felt he was entitled to a refund of his EMD, and the seller felt he was not entitled, and the seller was not going to give consent to the title company to release the EMD. Therefore, it's not going to be released because it would have to be released by mutual consent. So now we've got a situation with a stubborn seller who is not signing off on the release of the EMD, and a buyer who thinks he's entitled and might need those funds to go out and buy another house. I'm not giving any legal advice here. Please go consult with an attorney. But it's my understanding if the buyer filed a lis pendens on the property, and you have to do it legally and you have to do it correctly, you have to have legal cause to do that. You can't just slap a lis pendens on somebody's property. But if you did it properly on the property, then the seller couldn't sell, and might be an inducement for the seller to come to his senses, or at least to come back to the negotiating table. But I'm not a lawyer, so I can't give you that kind of advice. And let's take a look at paragraph 18C, which is the buyer default provision. It says, if buyer defaults in performance under this agreement as seller's sole legal recourse, seller may retain as liquidated damages the EMD. In this respect, the parties agree that seller's actual damages would be difficult to measure, and that the EMD is in fact a reasonable estimate of the damages that seller would suffer as a result of buyer's default. Very important sentence now. Seller understands that any additional deposit not considered part of the EMD in section 1B herein will be immediately released by escrow holder to buyer. So, if you go all the way back to where I did an explanation of paragraph 1B, back on page 1, that's the additional deposit. We talked about the choice there is to make, that the additional deposit will or will not be considered part of the EMD. I recommended to you when I did that paragraph that we choose will not be a part of the EMD. I said we'd get to it later. Here it is right now, that it's saying that even if the EMD is forfeit, the additional deposit is going to be refunded to the buyer. Okay, so there is the language on that. And just to conclude with this paragraph, I want to go back to line 52, where it says seller's sole legal recourse. So basically what that means is the buyer's liability is pretty much limited to the EMD. Sellers don't put up EMD, right? So it can't work the same way. And I think I might have mentioned to you that I'm not a lawyer and I can't give legal advice here, but it's my understanding that what this paragraph says in English is that the buyer's liability is limited to the amount of the EMD. All right, we are going to move on now to paragraph 19. If you can see just above paragraph 19, in the box it says instructions to escrow. It really should say instructions to escrow holder, in my opinion, but I didn't write this agreement. And paragraph 19 says, if this agreement or any matter relating hereto shall become the subject of any litigation or controversy, buyer and seller agree jointly and severally to hold escrow holder free and harmless from any loss or expense, except losses or expenses as may arise from escrow holder's negligence or willful misconduct. I'd like to bring your attention to the end of line 6 as well, where it says the parties expressly agree that escrow is entitled to file a suit in interpleader. Let's talk a little bit about that. I'm not sure if I mentioned in this video that I'm not a lawyer and I can't give legal advice, but the interpleader is where a title company is going to push the parties to go so that they don't have to continue holding the earnest money deposit. Those of you who have already watched my video series Class 2, where I do about an hour and a half or so on title and escrow, I did talk about the fact that in the state of Nevada, there is no statute of limitations on the time that a title company can hold earnest money. So actually, once earnest money goes into a title company, there's only 3 ways to get it out. And I covered this in Class 2 video series. One way to get the EMD out is to close the transaction. That's my favorite way. The second way to get the EMD out is by mutual consent, meaning the buyer and seller will come to some agreement as to where the money goes. It goes to the buyer, goes to the seller, they divide it somehow, they donate it to charity. Yes, I've seen that several times, but mutual consent for the release. And then the only other way, the third way that the EMD could be released in the state of Nevada is by a court order. If one of the parties decides to pursue pursue a legal action, and they get a court order granting the release of that EMD, that would be the third way. And of course, if there's a court order, the title company is bound to follow that court order. So they don't want these things to happen where the EMD is being held and held and held in perpetuity. So that's why the language is here on line 7 about the interpleader. It is another form of negotiation. Let us drop down to paragraph 20 now and talk about unclaimed funds. In the event that funds from this transaction remain in an account held by escrow holder for such a period of time that they're deemed abandoned under the provisions of Chapter 120A of the Nevada Revised Statutes, escrow holder is hereby authorized to impose a charge upon the dormant escrow account. Said charge shall not be less than $5 per month. So the word dormant, if you're not familiar, we use it in English. It actually comes from the French verb dormir, meaning to sleep. So when we say there's a dormant escrow account, we're talking about an account that's sleeping, an account where there's basically no activity going on. So the title company has the right to charge $5 per month as an administrative fee for their bookkeeping, record keeping, which of course they have to provide to the state. So they're chipping away at that EMD at the rate of $5 a month. You can imagine most of the time EMD is in the thousands of dollars. Chipping away at $5 a month is going to take quite a while to erode that money. So that is the instructions to escrow section. And now we come to the brokers section, and that begins with paragraph 21, where it says brokers' compensation and fees. Buyer herein requires and seller agrees as a condition of this agreement that seller will pay listing broker and buyer's broker, who becomes by this clause a third-party beneficiary to this agreement, that certain sum and or percentage of the purchase price, we call commissions, that seller or seller's broker offered for the procurement of ready, willing, and able buyer via the MLS or any other advertisement or written offer. Seller understands and agrees that if seller defaults hereunder, buyer's broker, as a third-party beneficiary of this agreement, has the right to pursue all legal recourse against seller for any commission due. Now on line 33, we come to some bold print. It's important. In addition to any amount due to buyer's broker from seller or seller's broker, buyer will or will not pay buyer's broker additional compensation in an amount determined between the buyer and the buyer's broker. Whether you check this box will or the box will not is completely up to you. But let me tell you how it works. TR Realty is going to charge a $299 residential processing fee. That fee is paid by the buyer if we represent him, paid by the seller if we represent him. This line 34 gives you the opportunity to disclose yet again the processing fee to your customer so that it is not a surprise, okay? Now, when it comes to the buyer's side of the transaction, if you are doing what you're supposed to be doing and what I have taught you in class 3, then you are going to present the TR Realty buyer's disclosure to the buyer right after the duties owed form is presented. And in that form, you have the opportunity to write the $299 processing fee and get it initialed by your buyer. This then would be redundant, and redundant is okay. Redundant is good. It is a second prophylactic, a layer of protection for you so that your buyer can't come back to you at the closing table and say, no one ever disclosed this fee to me. So if you check the box that says will, you're using this as a disclosure that you're going to collect the processing fee as it appears in the TR Realty buyer's disclosure form. If you check the box that says will not, what that means here at TR Realty is that you are authorizing us to deduct that $299 from your commission. So if you're doing a transaction for yourself or a family member or a friend and you wish to waive that fee, well, if it was my family, I would charge them triple on the processing fee, but maybe you feel differently. Or maybe it's a regular customer, repeat customer, they're doing a lot of transactions. You have the opportunity to go ahead and have that deducted from your commission instead of asking your buyer to pay it. So that's how paragraph 21 works. Let's take a look at 22, waiver of claims. Buyer and seller agree that they are not relying upon any representation made by brokers or broker's agent. Thankfully that, right? Buyer acknowledges that at close of escrow, the property will be sold as is, where is, without any representations or warranties, unless expressly stated herein. Buyer agrees to satisfy him or herself as to the condition of the property prior to COE. Buyer acknowledges, read along with me here on line 40. Buyer acknowledges that any statements of acreage or square footage by brokers are simply estimates, and buyer agrees to make such measurements as buyer deems necessary to ascertain actual acreage or square footage. And then, very importantly, it says buyer waives all claims against brokers or their agents for defects, for inaccurate estimates of acreage or square footage, environmental waste or hazards, the fact that the property may be in a flood zone, the property's proximity to freeways, airports, or other nuisances, the zoning of the property, tax consequences, or factors related to buyer's failure to conduct walkthroughs or inspections. Buyer assumes full responsibility for the foregoing. So, waiver of claims, this is a lot of protection for a real estate licensee and thankfully for their broker as well. So that is the brokers section of the RPA. Let's move on to 23, paragraph 23, which is the beginning of a section called Other Matters. And paragraph 23 is a bit of a glossary, a thesaurus, if you will, because it gets into definitions. Now, most of the words, hopefully all of the words in this section, you already know. If somebody asked you what these words mean, you could probably give a good working definition. That's great. the reason that this section appears is because somebody else might have a different working definition. And, I could circle back and talk about the word possession as an example, how possession has been interpreted to mean different things. Does possession mean ownership? Does possession mean control? So the reason they have these definitions here in paragraph 23 is so that the parties have one definition, pardon the pun, one definition to go by. So there's just a couple I want to bring to your attention here, starting with the word acceptance. Acceptance means the date that both parties have consented to a final binding contract by affixing their signatures to this agreement and all counteroffers, and said agreement and all counteroffers have been delivered to both parties. Now, here they use the word acceptance. I like to use the word effective or effectuation, but it means the same thing. And what it's telling you here, and God, this is something that I have to explain to at least one agent every single day. But what this is telling you is for a contract to be legally binding, not only must it be signed by the parties, but it must be delivered to the parties. If I sign a contract and I stick it in my briefcase and I never give it to the other party, there's no contract. Do you understand? So that's why this definition of acceptance is so important. We have to have the component of delivery, or we do not have a legally binding contract. Then I want to bring your attention down to line 6 on page 8. The definition of calendar day. Calendar day means a calendar day. Wow, that's ingenious, isn't it? A calendar day means a calendar day from or to midnight. So it doesn't matter if you go to sleep early. So when we start counting the effective date of the contract, so then we know our due diligence period, our mortgage application period, our loan contingency, appraisal contingency, etc. We have to know the effective date. And here, by definition, in this paragraph 23, it tells us what calendar day really means. It means up until midnight. Let's drop down to line 12 and look at the term delivered. Delivered means personally delivered to parties or their agents. Delivery to the agent is delivery to the principal. So, agents cannot sit on documents. They need to convey those documents to their principals without delay. So, when you get some more time, go ahead and read through the rest of paragraph 23, but those are the highlights that I wanted to hit. Let us move on to paragraph 24, which talks about signatures, delivery, and notices. 24A, down on line 28, it says, this agreement may be signed by the parties on more than one copy, which, when taken together, each signed copy shall be read as one complete form. Did you get that? The actual signature need not appear on the same piece of paper. As long as we have two documents that are duplicated, not replicated, duplicated, they must be exact. No difference at all, okay? One party can sign one, the other party can sign the other. We have a contract. So I want to be very, very clear of that. And that sometimes happens when we're faxing. It can happen in other scenarios as well. So we're allowed to take those two together to have an effective, legally binding contract as long as they are truly identical documents. 24B, when a party wishes to provide notice as required in this agreement, such notice shall be sent regular mail, personal delivery, overnight delivery, by facsimile, and or by electronic transmission to the agent for that party. I want to go to paragraph 25 now, and I want to talk about the IRC 1031 exchange. So I've been asked many times over the years, is that a typo? Should it say IRS? Well, no. IRC stands for Internal Revenue Code, which is the laws, I should say, of the Internal Revenue Service. The Internal Revenue Service, the IRS, is the entity. The IRC, the code, is the law, okay? So when we talk about an IRC 1031 exchange, we're talking about a tax strategy that will allow someone to take proceeds from a property, roll it over within a short period of time to a similar property, and defer the payment of capital gains taxes. Now, I want to be very clear. I'm not going to get too deep into this because I'm not an attorney and I'm not a CPA. So if you have questions about a 1031 exchange, you need to direct those to someone who is qualified to explain the details. I am not. But from my real estate perspective, the 1031 exchange will allow the deferment of those capital gains taxes. And years ago, there was a box to check. We would allow it or not allow it. Now it is written in here. A seller and or buyer may make this transaction part of an IRC 1031 exchange. The party electing to make this transaction part of an exchange will pay all additional expenses. All right, so the other party agrees to execute any and all documents necessary to effectuate such an exchange. So I often get asked about creating language that we can put into the RPA that allows one party to do a 1031 exchange. It's not necessary. It's right here. It's part of the template in paragraph 25. Let's take a look at paragraph 26, which talks about other essential terms. Beginning with the very first sentence that says, time is of the essence. Let's take a look at that phrase that we hear a lot, but do we really understand what it means? A lot of times people think time is of the essence means hurry up, go fast. That is not what this phrase means. Time is of the essence is a legal phrase that means the dates and the deadlines in a contract must be respected. Or the word I like to use is sacrosanct. Sacrosanct basically means respected to the exponential degree. So time is of the essence means when we have 10 days for due diligence, we don't have 11. When we have a 21-day appraisal contingency, we don't have 24. When we have a close of escrow set for July 17th, we can't close on July 18th. Now, all of those things can be changed by mutual consent, by drafting an addendum to the RPA, getting the parties to sign off on it, and then yes, we can change any of those things. But those new dates and deadlines must now be respected as well. Time is of the essence is very dangerous for a real estate professional because you have to make sure you don't allow your customer to go into default. It is your job. And you cannot hide behind the fact that, oh, well, I gave them a copy. They read English. They should know. You're the real estate licensee. You're supposed to know better. You're the one profiting in a professional sense from this transaction. Time is of the essence means you have the responsibility to ensure your client adheres to the dates and the deadlines in a contract. That's what that means. And then it says, no change, modification, or amendment of this agreement shall be valid or binding unless such change, modification, or amendment shall be in writing and signed by each party. That's the mutual consent that I was talking about a couple of minutes ago. Let's drop down to line 47. It says, should any party hereto retain counsel for the purpose of initiating litigation to enforce or prevent the breach of any provision hereof or for any other judicial remedy, then the prevailing party shall be entitled to be reimbursed by the losing party for all costs and expenses incurred thereby, including but not limited to reasonable attorney's fees. Oh, that's one of my favorite oxymorons, reasonable attorney fees. And costs incurred by such prevailing party. All right, let us flip to page 9 here. It says at the top, this form has been approved by the Greater Las Vegas Association of Realtors, GLVAR, which of course is now LVR. No representation is made as to the legal validity or adequacy of any provision in any specified transaction. A real estate broker is the person qualified to advise on real estate transactions. If you desire legal or tax advice, consult an appropriate professional. Let's drop down to line 12, paragraph 27 here, where it says addendum attached. Paragraph 27 is often misused. Paragraph 27 is for one purpose and one purpose only, and that is to write out the name of any addendum that you are attaching to this contract. So you could write in here as an example, short sale addendum to the purchase agreement. You could write in here as an example, addendum to the RPA, or anything else that might be relevant. But don't use 27 to create any kind of language. Simply write the name of the addendum that you are attaching. One that I mentioned to you earlier in this video was from paragraph 1, the seller financing addendum. That would be another example. And now, folks, what may appear to you to be the last paragraph of this contract appears to me as the most dangerous paragraph of this contract. And that is the one that says additional terms. And the problem with this paragraph is that you've got all that blank space where you just can't help yourself. You feel the need to play Matlock and to create some language. If you would like to put something in paragraph 28, let me give you some advice. Stop! Don't do it. Paragraph 28 is the number one paragraph that is going to get you in trouble. You are not a lawyer. You are probably not experienced enough to write language. And at TR Realty, you have a broker who is providing clause libraries to you, as well as 7-day support. Folks, don't be stupid. Don't create language on your own. If you feel the need to put something in paragraph 28, 90% of the time, it's because you have not read the contract. So before you ever add anything into paragraph 28, pour yourself a hot cup of coffee, start with paragraph 1, and read the contract. I'm telling you, about 90% of the time, an agent puts something in this paragraph, it's already in the contract. They just haven't taken the time to read the contract. And then, if you've read the entire contract and your issue is not addressed, the next thing you need to do is go to my clause libraries. Clause libraries have been included as handouts on all of my classes. Go there, read the clauses, see if I've already got standard language that you can use. And step 3, if you've read the contract and that doesn't cover your situation, if you've read the clause libraries and that doesn't cover your situation, now you get on the text with your broker and you ask me to address the situation. I cannot be any more clear. Never, never write language on your own. Got it? Let us move ahead to the buyer's acknowledgement of offer section. And starting on line 23 is a section called Confirmation of Representation. Now, up until many years ago, I don't know, 15 years ago or so, maybe I'm dating myself here, I shouldn't say that, but confirmation of representation was a standalone document. In fact, in commercial real estate, it's still used as a standalone document. But this was used in conjunction with the duties owed many years ago. Now it is incorporated into our residential purchase agreement. It says the buyer is represented in this transaction by, and if you are the buyer's agent writing this offer, which is, about 99% of the time, that's what it is, you need to fill it in, and you need to fill it in completely. You cannot leave anything blank. Buyer's broker's name goes right there. That's me. My name is Bradford Roberts. Not Brad Roberts, not Bradley Roberts, not Robert Redford. My name is Bradford Roberts, and you've got to get that right, along with my company name, TR Realty, and my license number. Folks, the license number for your broker and you, these are now required by CFPB guidelines. Federal law, you cannot leave them blank. My license number is on the contact sheet, but if you're lazy and you want it right now, It is B.0143293. Again, B.0143293. Phone and fax can be yours, not the company's phone and fax numbers. Agent's name and license number, that's you. Office address is whichever TR Realty facility your license is domiciled, etc. Make sure you fill it in completely. Do you understand me? You cannot leave the license numbers blank. And then we come to, on line 31, a section that if you don't do this right, the Nevada Real Estate Division is going to mop you up with the floor. This is a licensee disclosure of interest. And folks, if you don't do this right, you're breaking the law and you are subject to very, very severe ramifications. Get this right. It says, pursuant to Nevada law, a real estate licensee must disclose if he or she is a principal in a transaction or has an interest in a principal in the transaction. Licensee declares that he or she does not have an interest in the principal or does have the following interest, direct or indirect, in this transaction. So, if the principal in the transaction whom you are representing is someone who is not connected to you. They're not a family member, they're not a spouse, they're not a business partner, whatever it happens to be. Then you can go ahead and initial, and I like initials, by the way, does not have an interest in a principal to the transaction. Folks, if you have to ask, should I disclose, well, it's the cousin of my ex-wife, well, we're not really divorced yet, stop. If you have to ask a question about disclosure, always disclose. You're not hurting anything, okay? It's not like the other side is going to see this and run away from the transaction. So always err on the side of caution and disclose if there's some direct or indirect relationship. And then we've got a chance to check where it says principal, meaning you're the buyer, you're the actual buyer, or family or firm, meaning business, family or firm relationship. And if it's family or firm relationship, then on line 36, you got to say what it is. Sibling, parent, business partner, whatever it might happen to be. Line 36 must remain blank, however, if you've chosen does not on line 33. The only time we fill in line 36 is if we've indicated that we do have some kind of a relationship with the buyer. Moving on to line 38, this is what's often called a sunset provision. Some people refer to this as a response section. Whatever you want to call it, it is a deadline by which we are asking the seller to respond. Seller must respond by a certain time on a certain day, month, and year. It says, unless this agreement is accepted, rejected, or countered below and delivered to the buyer's broker before the above date and time, this offer shall lapse and be of no further force and effect. If we don't fill this in with a day and time by which we are asking the seller to respond, it would leave your offer on the table in perpetuity. So, 3 years from now, if the price of real estate drops precipitously and the seller finds this offer somewhere on his coffee table and he signs it, you'd be under contract. So we wouldn't want that to happen. And that's why an expiration or a sunset provision is such an important part of our offer. It says, upon acceptance, buyer agrees to be bound by each provision of this agreement and all signed addenda, disclosures, and attachments. So I want to make sure that we're very clear, because in some states, there's a document that precedes the contract. In fact, in commercial real estate, there's typically a document that precedes the contract. We call it a letter of intent. But in residential, we don't have such a thing. We don't use such a thing. So what that means in English is, if a buyer writes an offer, like the one we are covering here, and submits it to the seller, if the seller signs it, we are under contract. So all the more reason we need to know what we're doing in this contract, right? So that is the sunset provision. My recommendation is, if the seller is a person as opposed to an entity like a bank or something, we probably only want to give them a couple of days to respond. If your property's on the market, you're looking for someone to buy your property, you should probably be available when an offer comes in, and you should probably be able to respond within a couple of days, I would say. If the seller is an entity, a trustee or a bank as an example, I would probably give a week for a response. If you give them too short of a time period, this is just going to expire and they might not even get back to you. So that is how we use the response. Now, dropping down to line 43, the buyer needs to sign, print, date, and time the offer, okay? Because we are potentially halfway to a legally binding contract. So this is where the buyer signs, prints, dates, and times. Very important that they do that. Let's roll on to let's roll on to page 10, and we get to the seller's response section. Also, the confirmation of representation is here. You can fill in as much as you want. As per the MLS, you should be able to get most of this information. Go ahead and fill it in if you wish to do so. It's a nice, polite thing to do. And pay very particular attention, making sure that the listing agent and listing broker have their license numbers on this RPA. Folks, if they return this thing to you in an accepted form and the license numbers are missing, it's got to go back, or they have to redo it, or you can do an addendum. But license numbers for all 4 licensees, meaning buyer's agent, buyer's broker, listing agent, listing broker, all of those license numbers must be on the RPA, no exceptions. And then there's a section starting on line 11 for the seller licensee disclosure of interest. We've already covered what licensee disclosure of interest means a few minutes ago on the buyer side. This is where the seller would also so indicate. All right, and on those 2 licensee disclosures of interest, they can't be left blank. The parties absolutely, positively must make a choice. Let us drop down to line 18, which is the Srpd section. If you're not familiar with Srpd, you haven't watched my video series Class 2, where we talk about Srpd, which stands for Foreign Investment in Real Property Tax Act. Srpd is federal law. And the spirit of this law is basically to ensure that someone doesn't sell a piece of property, profit from that sale, and then take those profits offshore and not pay their share of income taxes in the United States. So we cannot determine as real estate agents whether our client is subject to Srpd. Srpd applies to foreign persons. That definition is not as clear-cut as it may seem prima facie. So since we are not lawyers and we are not title experts, the smart thing to do is if your customer has some sort of an idea that they might be subject to Srpd, have them call the title company. Now, I will tell you parenthetically, I've seen situations where a seller called title company A, they got an answer, they called title company B, they got a different answer, okay? I'm not responsible, you're not responsible for that, but the Srpd provision does need to be addressed here. And on line 28, seller declares that he or she is not or is a foreign person, therefore subjecting this transaction to Srpd withholding, and then the seller would initial there on line 29, attesting to the statement that they just made about their Srpd status. And we come to a really important section from lines 31 through 36, where we have 3 choices that the seller can make when the offer is presented to him. The first one is acceptance. Seller acknowledges that he or she accepts and agrees to be bound by each provision of this agreement and all signed addenda, disclosures, and attachments. I like initials here. If we're doing it on paper, if we're doing it electronically, I know it's a check mark. But in any case, if the seller is intending to accept the offer, we have to have acceptance chosen. In no case can a seller return to the buyer this RPA with none of those 3 choices indicated. So acceptance is the one that we like, right? The next choice the seller can make is a counteroffer. So the way this is phrased, because this does create some confusion, says seller accepts the term of this agreement subject to the attached counteroffer number 1. And I've heard some agents say, well, if they're counteroffering, they should not go ahead and sign here on page 10. Wrong. They need to sign on page 10 regardless. Just like the buyer signed on page 9, the seller needs to sign on page 10. And of course, if you are making the choice that says counteroffer, then that counteroffer must be attached to the RPA. And the third choice here is rejection. It says, in accordance with Nevada law, seller hereby informs buyer the offer presented herein is not accepted. And folks, this is always what we want to do in the case that an offer is rejected. We don't want to just disrespect people who took the time to submit an offer. Even if we're offended, we don't like the price or the terms or whatever, let's go ahead and get this rejected, signed, and turned around to the other side. And of course, as a real estate licensee, one of the frequent complaints that can be filed against you is failure to provide the offer to the seller. If the buyer's agent thinks that you didn't present the offer at all, they can turn around and file a complaint. Well, one of the best ways to stave off such a complaint is to encourage the seller to go ahead and reject the offer, sign it, and get it back, rather than just ignoring the offer that comes in. Something else I wanted to speak to before we conclude this residential purchase agreement, and that is the legal concept of intent. I'm going to talk a little bit about intent. Now, did I mention in this video that I'm not a lawyer and I cannot give you any kind of legal advice? In order to interpret a contract, in the event of a dispute, the court is going to look to what is called intent, okay? Sometimes people think that they can use a typo or an oversight as a way to get out of a legally binding contract. Well, if the parties decide to litigate and they go in front of a judge, the judge is going to look at something called intent, okay? Let me give you a small example of that. Let's say we draft an RPA and we indicate the property address is 123 Elm Street. We submit that to the seller. The seller owns 125 Elm Street. The seller signs this, we have a contract. Now the parties begin to do what the parties need to do, right? The buyer will apply for their mortgage, the parties will open escrow, the seller will order the resale package, they'll do an inspection, etc., etc. Well, let's say we get just before close of escrow and the buyer says, I just don't want to buy this house anymore. How can I get out of it? Oh, look at this. There's the wrong address on the RPA. Aha! I am going to use this as a way out of the contract. You know what, folks? While I can't speak for what any judge is going to do on any given day, I can tell you this is not going to be easy. Because look at what happened. Now, obviously, we have the wrong address. But how did the parties proceed? The parties proceeded as if the address was right. The buyer looked at the house. The seller ordered the resale package. The buyer did an inspection. The seller is beginning to move. And all of the other mechanisms of the contract are moving forward as if the address was right. That is a legal concept known as intent. And if a buyer or seller ever tries to get out of a legally binding contract based on, like I said earlier, some technicality, some typo, some mistake in the paperwork that was inadvertent, that was an oversight by the parties, they're going to have a very difficult road ahead because intent carries huge legal weight. So folks, that is the current version of LVR's residential purchase agreement. I hope that you've learned a lot so far in this video. I do have a few more things to go over, just a few more minutes before we wrap up for today. But in terms of the actual RPA form, that is it. And I hope that was really, really helpful to you. I want to mention that we do have another form available to us in Transaction Desk known as the Vacant Land Purchase Agreement. And the reason I'm not covering that right now is because it is very, very similar to the RPA that we've been covering here for hours, but in a very stripped down manner. And the Vacant Land Purchase Agreement, hear the word vacant, should only be used when there's no structure on the property of any kind. Not a barn, not a tool shed, not a silo, nothing. No structure of any kind. When the land is truly vacant, we don't use the RPA. We use the Vacant Land Purchase Agreement. If you can do the RPA, you can do the Vacant Land Purchase Agreement, and you can find it in Transaction Desk. I also want to talk briefly about the addendum to the RPA. We mentioned it, referred to it a few times in this video series. So let's go ahead and get that handout in front of us right now. You'll see at the top it says addendum number blank because addenda are numbered sequentially. So the first time we do an addendum, we're going to put number 1 on here. The second one is going to be number 2, etc. But the reason I mentioned something that sounds so elementary is because we never repeat the number of an addendum. Even if an addendum is drafted and it is not effectuated between the parties, even if it's put through the shredder, the replacement addendum is numbered sequentially. We do not repeat that number. Now, I don't need to spend a lot of time on the mechanics of this form because if you followed me all through the RPA, you can certainly fill out this addendum. It is, for the most part, a blank form. It's a question of who is proposing it at the top, the property address, the parties' names, etc. Lots of blank lines that we could use for stuff as long as the stuff is not written by you. So you could use my clauses from my clause libraries, or you could have an attorney write something, or you can come to your broker and I'll be happy to help you as well. Often, this addendum is used later, and we're going to talk about that in just a moment. In the middle of the page, it says additional pages attached. This addendum is not complete without the additional terms on the attached page. So if that blank space is not enough and we need even more space, we could go ahead and we could attach and indicate here. And then you can see whoever is going to proffer this addendum is going to sign, date, and time this. And then we have a chance of acceptance by the other side who's also going to check the appropriate box, sign, date, and time. And down the bottom, we have a place to indicate the agent's name who prepared this addendum. It doesn't have to be signed. We can just go ahead and print the agent's name. I know that's a little bit unusual. We don't typically do that, but that's the way this form has been designed by the association. So let me circle back here. I mentioned that this addendum is often used later. Very rarely it is submitted in conjunction with the offer. It's usually something that we do later, so maybe technically it should be called an amendment, not an addendum. But nonetheless, I want to make sure we know the difference between a counteroffer and an addendum. So the counteroffer, I get asked this a lot, by the way. The counteroffer form, listen to the name, counteroffer. The counteroffer form can only be used during the offering stages. So when the buyer writes an offer, submits it, the seller responds, I don't want this, I want that instead. That's a counteroffer. So when we are negotiating back and forth, that's when we use the counteroffer. Once we have an effective contract, we cannot use the counteroffer form anymore. However, the addendum can be used at any time. It can be used as part of your offer, or it can be used later on. Once we have an effective contract, we need to go back and we need to change something like the closing date as an example. We would do that via an addendum. I want to talk about the case where the closing is delayed. because I believe the delay of COE is probably the most frequent use for the addendum to the RPA. And obviously, if your closing is going to be delayed or extended, you have to get mutual consent. This goes back to my explanation of the phrase, time is of the essence. If we have a contract set to expire on March 14th, you know what we have on March 15th? We have scrap paper. That's what we have. And it doesn't matter how friendly the parties are, they're getting along, kumbaya, everything is wonderful. At 5 o'clock p.m. on the 14th, we have an expired contract. And now it could bring up all issues about performance, specific performance litigation, default, and other ugly and nasty things. So if we are getting to the 14th and one of the parties is not able to perform by that date, that party needs to ask the other side for an extension of close of escrow. And as I said, that is probably the number one way that this addendum is used. I'd like to bring your attention to my clause library from today's video series, specifically clause 5.01. Please get that in front of you and follow along with me here. It says, seller and buyer hereby agree that due diligence or appraisal contingency or loan contingency or COE, as stated in some paragraph and line number, shall be amended to some date. So folks, this is the standard language that you would use if you're extending any of those things: the due diligence, the appraisal contingency, the loan contingency, or the close of escrow. Now, sometimes we're actually extending more than one thing. Sometimes there's a delay in the transaction, and we need to bump more than one of these things out. Not a problem. Take out the parts of this that don't apply. If you're only extending close of escrow, as an example, then take out the due diligence, the appraisal contingency, and the loan contingency, right? So use the language appropriately. And then it says, as stated in some paragraph number and line number. So you're going to actually reference to the place in the RPA where the thing that you want to extend actually appears, and you're going to cite that paragraph number and line number here as part of your clause. And lastly, shall be amended to. This is where you're going to put in the new date that those things are going to expire. So folks, that is the clause, that is the use of the addendum, that is the RPA. I feel that we have hit it out of the park today for our understanding of the purchase and sale agreement. I hope you agree, and I'll see you in the next video. I would like to thank you for watching this video. I hope it was informative for you. If you are licensed with another brokerage in Southern Nevada and would like to talk with me, please text me or visit our website. See you next time.